Hello, good morning. I'm just letting people get logged on here, so bear with me. I'm coming. I'm a little early this morning. Yay, at least I'm not late. All right, just letting people in. Bear with me, you guys. We'll talk about Senate Bill 91. Oh, I have an electrical outlet behind me. I'm like, what is that? Just give a few minutes to get everybody logged on. If anybody has questions, you guys can unmute yourself and ask me. I'm okay with that today. We're less structured, or you can type in the chat. It's up to you.
I have a question.
Go ahead.
Okay.
But first, tell me who I'm talking to.
Oh, your servant, David Yermian. How are you?
I have no servants.
Okay, look,
All right.
I went to Housing is Key, and then I also attended some YouTube seminar by AOA and AOA USA. They're telling me that this February 28th deadline for that is to be given only for that are behind payment from March 1st, 2020 to June 30th, 2021. And it's, if I'm correct, is the...
Okay, stop right there. How do you know if your tenant is going to stop paying the rent on March 1st? You don't.
Well,
You
see,
don't.
okay.
So if you don't serve it to the tenant that is paying you now, you're putting yourself at risk for being able to do anything later.
Oh, I see.
Okay, so they want you to disclose it to everybody. And here's my theory, okay? Your honest tenants that are paying you are going to continue to pay you because they're honest tenants.
I see.
If they were going to manipulate the system, they would have started doing it long before this.
I got you. I understand. Okay, but to be sure, we are serving, to be sure, we're serving the Civil Code of Civil Procedure 1179.04B. That's the one that we're serving, just to be sure.
Yeah, that's the one that discloses to them about how they can apply for the 25% and how the federal government could pay up to 80% of their past due rents and their landlord would forgive the 20%.
Yes, it's something. Yes, it said here.
Yeah, I have the bill here. It's atrocious. I don't know if you can see all the pages.
Yeah, but it starts by saying that California legislature has enacted the COVID-19 tenant relief act.
Done. You're right there with California legislation has enacted the COVID tenant relief funds. That's what you need to serve.
Okay, perfect. And then we're gonna serve it. I don't think, you know, I got 87 units. I cannot just take picture. I'm gonna just send them all with maybe registered USPS.
You can do that. Actually, you can go to the post office, and when you mail it, you can get something called proof of mailing.
Yeah.
Okay, proof of mailing will help you. And I'd fill out that proof of service.
Okay, I see. All right, so just to make it.
Chances are you have 80 something tenants. I'm going to assume right now that more than 90% of your tenants are paying the rent. Is that correct?
Yes, it is true. Actually, it is true. 100%.
Okay.
Yes.
How did I know that? There's no way I could have known that. For the most part, tenants are paying their rent. The ones that aren't paying the rent either are genuinely affected by COVID and they have a genuine problem, or they're manipulating the system to benefit them. We can't get too mad at them because if we could manipulate the system to benefit us all the time, wouldn't we be better off? I'm kidding. All right, I see it. We got quite a few peeps on here now, I think. Let me just go look and see who we got. And then we'll go ahead and get started. I'm ready to start if you guys are. Anybody else have any questions before we get started? I'm going to talk about Senate Bill 91 because that's what's in our face right now and what we're having to do with. And I have some key takeaway points, okay? And sometimes when I do a webinar with somebody else, I don't always include my personal opinion because some people get offended by me. Hey, go figure. So just want to go over Senate Bill 91 really quickly. What do we have to do? Because that's what we need to know. Just tell me what I got to do. So for the new Senate Bill 91 that just came out, by the end of this month, by the end of February, you need to notify all your tenants of their rights. That is a given. And the reason that I can't push that enough on you guys is it is the basis for a lot of caveats down the road. Okay. So example, if you don't disclose to your tenant by the end of this month what the rules are and the new laws with that moratorium, I'm sorry, it's mandated, so it's required by law. It's not a moratorium. This is regarding Senate Bill 91. If we don't disclose to them by February 28th and they stop paying us in March, we're not going to be able to do an unlawful detainer action unless we can prove, number one, we've notified them of their rights, and number two, we've applied for the money. Okay, you're not going to be able to apply for the money if you didn't notify the tenants of these rights. So I can't stress this to you guys enough. You need to notify all of your tenants, whether they're paying you or not, about this new law and the Senate bill and the mandated disclosure, because there's a lot of caveats that play off of it. You will not be able to evict for non-payment of rent unless you can prove that you applied for the money. You cannot apply for the money unless you disclose to your tenants of these rights by the end of this month. So it's like that triangle where you have to go get in line A so you can get to line B so you can get to line C later down the road. I can't encourage you enough. Make sure you're disclosing to all your tenants the new mandated disclosure that needs to be in place by the end of this month. Those of you that have tenants that are paying you, they are your honest tenants. By giving them a notice of what their rights are doesn't mean they're going to stop paying you. Usually, if they were going to stop paying you and take advantage of something, they would have done it already. Okay, just saying. So don't let that be a fear factor for you. Yes, it kind of is a possibility, but the likelihood of that happening is very low, just so you know. Okay, trust me here, please, I beg you. So we want to make sure that we're disclosing to all of our tenants by the end of this month the new rules. Okay, it like I said, going forward in an eviction for non-payment of rent, at least until June of this year, we're not going to be able to evict them unless we can show that we've given them this disclosure. We're also not going to be able to evict them unless we can prove that we've applied for the money from the state. Let's talk about that really quick. The website is housingiskey.com. If you go on it now, they provide 4 documents-ish. I checked it out. Those aren't real documents. Are you paying attention? Do I have your attention? They have 15-day notices on there, or an example of a 15-day notice. If you read the fine print, it clearly says that this isn't fully compliant with California's civil procedure. This is me talking to you. If you look at those notices on housingiskey.com that they put up for examples, they do not include the hours of which to pay the rent, the days of which they can pay the rent. It doesn't ask for a phone number of who to pay the rent to, nor does it ask for an individual of who to hand the rent to. Therefore, the notice is invalid. They're putting it up there as an example. It is not a complete notice. Do not use the notices off of the Housing is Key website. They are not valid notices. Trust me, okay? And just think about it. Your regular 3-day, your 15-day, it all had hours and dates that you could pay the rent, who to pay the rent to, the phone number. These notices they have on Housing is Key doesn't have any of that. They are examples. They are not good examples, okay? they're not in compliance with California Civil Procedure 1162 subparagraph 2 specifically. So if you use the notices that are on housingiskey.com, you're going to fall on your face. Okay, face plant. Don't do it. Okay, it's just an example. It even says it in the fine print. Please don't use those documents. I have way too many people that tell me, oh, I served the 15-day. I got it from the BRE's website. And I'm like, no, it doesn't have everything that's required. It's not in compliance with California law. So we need to be very careful that we are not implementing the notices that are on the Housing is Key website. Those are not valid notices in a California court of law. They are an example. And between you and me, it's a bad example because it doesn't have all the stuff that's required by law. So don't use the notices off the Housing is Key website. It is an example. It is not correct. It doesn't comply with California Civil Procedure, and it will set you up for failure. Does our government do that? Do they set us up for failure? No comment. Okay. All I'm telling you is don't use those docs. So we need to have all of our tenants notified by February 28th so that we can apply for the money going forward, because we're going to have to show that we notified our tenant. In order to evict, we're going to have to show that we applied for the money. In order to apply for the money, we have to show that we notified the tenant. So it's all this conundrum that goes around a lot of moving parts. Everybody needs to notify their tenant on or before February 28th of the new California law. Okay, simple. Don't use the documents off of the website. Okay, don't do it. Housingiskey.com, those documents are an example. They're a bad example. They don't comply with California Civil Procedure. They don't, it's a recipe for disaster if you use those documents. That's all I'm saying. They don't comply with the law. And they tell you that in the fine print. If you read the disclaimer all the way through, it actually tells you how to contact a tenant advocate group or a law firm or somebody to help you, and says that these are just for example purposes because they don't have everything that they need. I saw a couple questions come through, so let me just check on them really quick before I move on. Do I have a copy of the correct forms? You can get them from your apartment association or from your legal counsel. I know Fast Evict will serve the document for you. It's $175 for them to prepare and serve. All tenants are delinquent tenants, all tenants. You can't apply for the money and you cannot evict going forward unless you've notified all your tenants of their rights. What if we give our honest paying tenants this notice and they apply for the 80% money? They can't apply for the 80%, only you can. So let's talk about that really quickly, okay? The landlord applies for the 80% and forgives 20%, and now your tenant's current. You don't need to evict. You gave away 20% and you got 80% from the government. That's it, you're done here. I don't know a nicer way to explain it, okay? You got 80%, you gave away 20%. A lot of you have told me, and I keep hearing this, I don't want to give away 20% of my rent. That's not okay. I'm not all right with that. Tell that to your restaurant down the street and how they've been affected by COVID. Tell that to the mom and pop hardware store that had to shut their doors, or the hair salon, or the nail shop. You guys with me yet? We as landlords are the only people that I'm hearing about that is getting a decent bailout. Yeah, we're going to have to give away 20%. It's better than the alternative. And we'll talk about the alternative in just a second. Okay. So the 80%, let's talk about that really quick. You want to go to housingiskey.com. That's housingiskey.com. Again, do not use the notices on there. They're not in compliance with California Civil Procedure. They're up there for an example. They're a bad example, in my opinion. Don't use those documents. They will set you up for failure badly. Okay. March 15th is the first time landlords can apply. 5 a.m., you guys. If it's a federal program, then it should run on New York time, right? We don't know yet. So my opinion is set your damn alarm for 4:30 a.m. because at 5 a.m. you want to be logged onto that website and starting to apply. Ed, why are you shaking your head at me? Because you know I'm right, huh? You know I'm right.
Which website? Is it the Housing is Key website on which
Housing
we
is
should go
key.
to?
Housing is key website, but you can't apply until the 15th of March.
Patty, is it
And my-
limited? Is it limited? Like, is it a race for the funds, or?
When the money's gone, the money's gone.
I see.
Don't you think corporate America has a whole team of people ready to apply for all of their properties? We need to beat them. You guys, we got this. Come on. And honestly, and I'm not trying to scare you, corporate America doesn't really have a problem with delinquent rents. And Ed's going to look us all dead in the face right now, and he's going to tell us how much his delinquencies are. And I'm going to guess that they're less than 10%. Am I right?
Approximately, right.
10%. Okay, so corporate America isn't having as big as a problem as us in single family management where it's an eye for an eye. Okay, example, you own a 15-unit apartment complex or a 1,500-unit apartment complex. 10 people don't pay the rent, it doesn't kill you. It may make it a little uncomfortable for a while, but it doesn't kill you. You can still make the mortgage, you can still function and do repairs. In a single family residence, that tenant isn't paying the rent. That's an eye for an eye. You can't make the mortgage without their help. So totally different set of facts. I don't think we're going to see a big increase with corporate America applying for these funds and swiping us out because they really don't have a delinquency problem.
Patty, I have a clarification question. I'm not trying to be difficult here, but I think the instructions for that notice that's due by February 28th to notify the tenants. I think it said we're only required to notify the delinquent tenants. I understand.
Right, and this is what I'm trying.
No, I understand. I understand what you're saying. Why you're saying to notify all the tenants, so that later on we can apply for funding if we need it. My fear is if I notify all the tenants, they're going to go, "Oh, really? I'm going to stop paying now."
But your honest tenants have been paying you all the way through this. They're not going to jump ship at this point. Trust me, because they all have the mentality of they're not going to give me the rent for free and I'm going to have to pay that back someday. And we all know, and all of us know this, because if we don't, we know this right now. Let me tell you, once you get behind, it's extremely difficult to get caught back up again. Tenants that are genuine good tenants know this, and they don't like to get behind because it's harder for them to get caught up again. Simply said. So those of your honest good tenants are not necessarily going to go jump on the bandwagon. If the tenant was going to go jump on the bandwagon, they would have done it already.
Okay.
I'm just saying, we're at the Hail Mary part. Okay. I see light at the end of the tunnel. Hey, you guys, I know I've been talking. It's not time yet. It's not time yet. We got 2 pages of retaliatory issues in the new Senate bill. That tells me that the state is more likely to continue to open rather than to be extended and closed down. But what do I know? I'm just a blonde. But I'm telling you, now that I'm seeing the retaliation things in there, I'm seeing these things, this is telling me it's coming to a head. But again, I don't know everything. Come on, you guys. Don't put that kind of pressure on me. So notify all your tenants so that in the event they stop paying, you can collect the money, you can evict. There's a lot of caveats that go behind this. So 5 a.m., housing is key on the 15th. Do not use the documents on that website. They are not valid documents. Use them from your apartment association, get them from your legal counsel, but don't use the ones that are on that website. They don't comply with the California Civil Code. If the landlord decides that they don't want to participate in the funds, the tenant can then apply for the 25% so that you can evict them. Okay, just apply for the money. I'm not trying to be an ass. I'm not trying to be a jerk, but let me put this in perspective for you. If we didn't apply for the money, we're not going to be able to evict for non-payment. And how it's written right now is 25% of the rent is due on or before June 30th. The 75% balance is considered consumer debt. We can never evict for it. We can only sue in small claims, and that debt is unassignable. What does that mean? It means you have to figure out how to collect it. Doesn't it make more sense to take the 80% that the government's going to give us, write off the 20% instead of trying to figure out how or when or why we can collect 75% going forward? I mean, collections isn't easy, you guys. That's another full-time job. You're talking about getting writs of execution. You're talking about getting the sheriff's department involved. You're talking about serving an employer to garnish wages. It's a whole nother process. Okay, it's not easy. So 80% doesn't sound so bad. And if you think it does sound bad, please, I beg you, go talk to your local restaurant and see what they'd say about taking 80%. Okay. Let me see. I got a couple more things I want to bring to your attention. Rent increases. For those of us that increased rent during the pandemic at all, and our tenant has been behind at all, that is now deemed retaliation. We cannot increase rents during the pandemic unless they have not been behind at all during the entire pandemic, okay? So we need to reverse those charges immediately, make sure we're showing proper credits on ledgers, etc. Nobody needs that coming knocking at them. They have put fines in the new law that are expensive. They're very expensive. It could be up to $2,500 for each occurrence. We don't need that. Yes.
Since when do we need a check? Since April 1st, 2020 or what?
April 1st of 2020 to date. No rent increases, no additional charges, no additional expenses to be given to the tenant. No additional expenses. So if you did a 30-day notice of change of terms of tenancy to make them get renter's insurance, could that be considered an additional expense to the tenant? Absolutely. Reverse it. Go backwards, eat crow. We cannot charge late fees throughout this whole time period.
What if the tenant caused damage to the unit and we charge them for that?
Damage is damage all day long. But I'll tell you this, I wouldn't even put it on their ledger until July 1st. And that's just me talking to you.
Patty, it's so depressing to talk to you every time. I know it's not you, it's just like that.
Well, I could sit here and go, you can do whatever you want. But reality is I'm not giving you good, solid direction at that point, and I'd rather make sure that we're erring on the side of caution so that nobody gets involved in a lawsuit. I always use this as an example, so forgive me. I know you guys have heard it before. We have a lady in Northern California a couple years ago when they passed that no rent increases during a global or during a state of emergency. She increased her rent $3,000. She's now being held 3 counts of misdemeanor price gouging during a state of emergency. It still hasn't gone all the way through trial. She's looking at $30,000 in fines and 18 months in jail. We don't want to run with our heads cut off, okay? To go make this new law happen when we don't even know what the rules are. We got to be really careful that we're not setting ourselves up for failure, because they added 2 pages of retaliatory issues to the new bill. I saw a question come through and I'll get to you in just a second. Hang on. So no additional expenses can be given to the tenant from the time the pandemic is started all the way through June. No late fees, no rent increases, no interest charges, nothing. So if you've done something like that, you need to reverse it before it bites you. Yes.
What if Section 8 increased the rent?
Then Section 8 increased the rent. That wasn't you. Okay. Hit the easy button.
Okay.
You didn't do it. The federal government did it. That's a them problem, not a you problem.
Okay.
Okay. Okay. Make sure that when you're screening going forward, think of this way, you guys. The COVID period is a bubble. And the tenants in the bubble, and they're protected through COVID. They have been this whole time. It's not going to change, okay? When you're talking to a landlord down the road, the COVID period is a protected period. You cannot disclose whether or not they paid the rent or were late on the rent during COVID, okay? That would be discriminatory, and you would be susceptible to fines. Don't go there. It's also retaliation.
So sorry, I'm asking questions. I hope it's beneficial for everyone. If not, tell me to shut up, I'll shut up. But my question is, when screening, we have a rental verification form that we send out. On it, it asks, has this tenant ever paid late? Do I now need to split that into two questions, saying, has he ever paid late prior to COVID? Or how do you structure it?
You're just asking the question. If they answer it, so be it. It's you answering it that I'm concerned about.
Oh, okay. So if someone
I'm not concerned about what you're asking people. I'm concerned about the information you're giving people.
Okay. But if
you cannot disclose what happened during COVID, the tenant's in a bubble and they're protected. If somebody else opens their mouth and tells you something, hey, that's not a you problem. Okay. The problem is what comes out of your mouth. That's where you're going to get sued.
But we could also get into an issue if we are told that a tenant did not pay during COVID and we use that against them.
Absolutely. That's retaliation. They are protected during the whole COVID pandemic.
No, I understand that. But if I'm asking, has the tenant ever paid late, and they go, yes, but they didn't tell me if it was in COVID or pre-COVID, or they just
then they've paid late.
And then I can use that.
Yes.
Okay, as long as the landlord.
Where you're getting in trouble from the way I read the bill is by giving out that information. That your tenant was protected during that time. Continue to protect them, because it's only going to get you in trouble. Okay? So I would use words such as, we don't disclose what happened during the COVID pandemic, as it was a protected period for tenants.
Okay.
Okay.
I can ask all day long if they've been late or not been late.
You can ask if somebody's been late or not been late. You can ask whatever you want. What I'm concerned about is what comes out of your mouth when someone else is asking you.
Okay.
That's where I'm concerned.
Okay.
Because if they're telling you they were late all the way through COVID, that's their problem. I don't want you telling anybody anything about what happened during COVID with that tenant that you have.
Understood. But if someone tells me that their tenant hasn't been paying all through COVID, and everything is otherwise fine with that tenant, meaning they have a 700 credit score and good income, I can't deny.
You can't hold that against them. Bingo.
Okay.
Bingo.
Right.
COVID's a bubble. Tenants in the bubble. Keep protecting them, okay?
Yeah.
It's not worth the fines, you guys. Trust me. Trust me. Okay, so very important. Late fees, can't charge them. No additional expenses to the tenant. If you've done so, reverse it on your ledgers immediately. It's a lot easier to fix it now than to go back 5 years from now and correct things like this. Okay, so if the, Jackie, I see your question. Okay, 80% and 20%. What about the tenants supposed to be paying the 25%? Here's the deal. If you apply for the 80% and you get the 80%,
that's it.
They could pay you through June of this year, even though it hasn't happened yet. So keep that in mind. You can apply on March 15th. I don't know how long it's going to take for them to actually issue you the funds. Okay, we don't know yet. But what I'm saying is, if it takes you that 80%, the 20% is forgiven. Now the tenant doesn't owe anything. Okay. Everybody with me? So it's two different issues. If you're going the 25% and the tenant's paying 25%, 25%, you can still apply for the 80%, but it's 80% of the balance that's owed. Okay, just so everybody gets that. So if your tenant's been paying you $250 every month and their rent's $1,000, they've been paying the 25% all along. But now you want that other $750 that you should have been getting every month. Now you can take that amount and apply for the 80/20 through the government. Okay. In the event you don't participate, and I'm telling you, don't walk to sign up for this money, run. You guys, and you've never heard me say run any faster for a government program because I think they're all a bunch of bureaucracy and bullshit. But this one actually makes sense, okay? So I'm telling you, do not walk, run to go apply for this money because once it's gone, it's gone. There is no more bailout. Restaurants aren't getting bailed out. Other small businesses are not getting bailed out to this extent. We need to grab a hold of this. This could be our Hail Mary plan to keep our properties, okay? Just saying. So we want to make sure that we're applying for those funds. Let me see if I can, and I hope that answered your question, Jackie.
Patty, I have a question.
Hold on, and I'll take your question. April, this is for the entire state of California. The 80-20% that we're talking about is for the entire state of California. Okay, what's your question?
Let's say we apply for the 80%. Are the tenants notified immediately about in reference to that? Because what I'm wondering is what happens in between the time that we apply for the 80%, the tenants come in and start paying their rent or bring in money bring in part of that money that's due?
I think there'll be some adjustment time in there for that. To be extremely honest with you, I don't know all the details of the program, and to be very honest with you, neither does the government. That's why when you go to the website, all you see is 4 BS freaking forms that aren't complete. Do not use the forms on that website. They suck, you guys. They are setting you up for failure. Don't do it, okay?
Okay. Thank you.
But I don't think they even know all of the intricate details of the program. And that's why the law passed and they're giving themselves a cushion before the landlords can actually apply, is so that they can put all the process and procedure in place. Does that make sense?
Yes.
Okay. And then I'm going through questions. No late fees. Can't charge any late fees all the way from March of 2020 through June of 2021. Late fees, there was nothing in the law saying that we couldn't do late fees. Now there is. Now there's something in the law that says we can't. 80% of the balance owed. Yes, bingo. Under LARSO, I billed a tenant for a repair I made before April of 2020, but did not invoice them until July of 2020. Am I okay? It's on their ledger prior to, I wouldn't worry about it. Am I okay with the payment they made around September 2020? If they made a payment to pay off a damage that happened prior to COVID, I wouldn't be concerned with it necessarily. Okay. I hope that answers that question.
Patty?
Yes.
I have a question. How bad would it be? Because for me, I have, a few hundred tenants, and for me to go through all their ledgers and double check that we didn't, increase their rent and everything, it'd be easier for me to send a text message or an email to all the tenants saying, if you received an increase, which occurred between April 1st of 2020 and today, please let us know, as it is invalid and we will reverse it. Is that okay to do, or is that not advisable?
Oh, you could totally do that. But my question now becomes, how many of them didn't get a rent increase? They're going to tell you that they did.
Oh, no. Once they do, I'll go back and check it.
I'm being an ass. I'm being an ass.
Once they do, I'll go back and check it.
I think it's a great way to do it. But what about that person? And this is just me talking to you. And yes, that didn't get the text message, got a new phone number. They have a rent increase. It's now 5 years down the road and you didn't catch it.
So I have to go through ledger by ledger now.
I mean, I hate to be an ass, but you're going to have to.
Okay.
You have Appfolio, yes? Should be a relatively easy task.
Is there a way to automate that in Appfolio that you know of?
Off the top of my head, the answer to that question is no, but I'm sure if you called out Appfolio, they would tell you which report to run. Wink, wink.
Okay, no, fine.
You're welcome. Because I know there's a way to do it. I just, not today.
Got it.
I have a question. I have a question, Ed. Since you mentioned you have 200 or 300 units. How are you going to mass mail this form before February 28th? How are you going to do it? I mean, is there an efficient way of doing this? So I could learn from you to do it fast and efficiently?
We're going to print them out. I mean, there's no shortcuts. Unfortunately, we're going to print out the couple hundred notices and stuff envelopes. I have a staff here, and each one of us is going to have to do 50 or 60 of them and get it done. I don't.
You're going to go to the post office and ask for proof of service for each one of them?
Oh, that's a good question. I don't know, Patty. What do you say about that? I mean, that's going to be a big expense.
Yeah, and if you want the proof of mail, that's another $10. You're talking about $2,000 to $3,000 here.
Right. Patty, is
And
it
see, I have questions too. Are you talking about having them in an apartment community? Because in an apartment community, it's easy to do because they're all in the same place. And you could actually personally go post them on their doors and get done with one apartment quicker than you could anything else.
So we can
I mean,
take a
this
picture
goes-
of post. Yeah, we can take a
Yeah,
picture.
you could
after
fill out a
posted.
proof. You could fill out a proof of service if you just go by and post and mail.
But just a regular stamp is not going to cut it.
I wouldn't trust a regular stamp with this in my particular scenario. Is it something your attorney could argue later that the intent to notify him was there and it got lost in the mail? Yes, absolutely. But it's not up for you or me to decide. It's up for a judge in a court of law.
Right.
So my theory is cover your asset.
No, I understand, but now that's a $2,000-3,000. Like you said, it's a $2,000 to $3,000.
I completely understand. I get it. Okay. But if you have an apartment community, that should be easy. Maintenance can go serve them. You're just going door to door at that point, and then mass mailing. Super simple, regular snail mail, no proof of mailing required. Fill out your proof of service, put it in their file.
We can tell the manager, bring him to the office, have him sign a copy that they received it, and give him another copy.
They don't need to sign this document.
No, I understand. Just to prove that we gave it to them, we can tell the manager to get their signature after.
The proof that you gave it to them is filling out a proof of service.
All right.
That's what's recognized in a court of law.
Okay.
I'm going to try all day long just to revert back to it. And it's because when you get into court, the judge is going to ask, do you have a proof of service on this? That's what they're looking for. Got me?
Manager can do
you
that.
Guys paying attention? That's what the court wants to see. That's who makes the rule and who's going to decide whether or not the tenant was served based on that document, which is your proof of service. Okay, let me see. I saw some other questions come back. What if our property manager does not want to send this out? Obviously, as the owner, we would be the one to be sued. So this is awkward. I'm sure Ed's going to pipe in and help me on this question. And I'm going to make this statement very clear. Okay. As a landlord, when you hire a property manager to represent you, they are an extension of you. And you, as the landlord, are ultimately responsible for everything that comes out of their mouth. So you better hire a good management company to represent you because you're ultimately responsible for whatever they do. I would ask them why they insist on setting you up for failure.
Plus, it's your say. You're the owner of the property. It's not there. It's not. They're there to service you, not you them. And what was I going to say? I don't know, Patty. Correct me if I'm wrong, but if you're the owner of a property management and your property manager doesn't want to serve it, why don't you just serve it on your own?
Absolutely, because remember, you're not going to be able to evict for non-payment of rent if they stop paying you in March, unless this notice is served. You can't apply for the money unless this notice is served. So my question to you becomes, is your property manager going to pay the rent? It's a good question to ask them. I'm just saying, but that would be my I'm choosing my words carefully. That would be my snooty response to my property manager. If, oh, are you going to pay my rent if the tenant doesn't pay, since you don't want to give me the tool that I need to enforce the law or to benefit me in the event they stop paying? And the reality is a good tenant that's been paying the rent through this or is current right now isn't going to stop paying you just because they got notified of this. They're not. Trust me, okay? If they were not going to pay you because of the rules benefiting them, they'd be doing that already. This would not even come into play, okay? Let me see what other questions we got. They weren't even aware of this small town. We don't live there. Totally understand that they weren't aware. If your property management company isn't aware of the new laws, I strongly and highly recommend that you encourage them to sign up for Widget's Way and get involved with a law firm that keeps them in the know. The whole reason that I started Widget's Way, you guys, just so you understand, is when COVID hit, we couldn't get together. Ed knows I usually come talk at NARPA meetings, and he comes and takes classes from me all over Southern California. We couldn't do that anymore. So I designed and developed this program to keep us as landlords and property managers in the know so that we're not breaking the rules. Because the rules have been changing so rapidly throughout this COVID pandemic, I felt the only thing that I could do to keep us all tied together so that we didn't end up in lawsuits and losing our properties was to keep us all in the know. And that's why I did this. I even called it in the beginning, it's like a property management support group, because we didn't have anything. I mean, and we don't get to interact the way we do here on Widget's Way. When you take a webinar, sometimes your question doesn't even get answered. And I get that. It's because they have so many people through the webinar. But that's why I started this, is so that we could get the answers to the questions that we needed the answers for, so that we could all stay in the know and be on top of what was happening. And sometimes just having somebody else going through the same situation you are helps you sleep better at night, because you realize that you're not alone through this. And you guys, we're not alone. We're all connected. We're all in the same storm.
Cue in the song by Michael Jackson. You are not alone.
You are not alone. Simply said, we're all in the same storm. We're not all in the same boat. Some of us are in a kayak, some of us are on a yacht, but we're all in the same storm. Okay. And that's just the way I want you to look at it, because some of us are sinking very quickly. We haven't been getting any funds. We are already at notice of default, looking in the face of notice of trustee sale, hoping that we get this 80% before they foreclose. I get it. Okay. I'm with you. Some of us are on a life raft. Some of us are in a cruise ship. I mean, you just don't know everybody's circumstances, but we're all in the same storm. And my goal here is to keep us all in the know on what's going on and making sure that we're protecting ourselves and not exposing ourselves to unnecessary lawsuits, especially now that they added the 2 pages of retaliatory issues. If you have ever, during the COVID pandemic, served a 15-day notice to pay rent or quit, and you now want to go after cause because they have all these material breaches of the lease, that's considered retaliatory. Okay, so we want to be very careful that we're not retaliating. We have to approach everything with kid gloves. How could we ask for money, and then go after cause if we have a police report or an arrest record? And this is where police power comes in. And forgive me, I know I just used a really weird term to some people, but police power is much different than police officer, okay? Police power is your zoning, your code enforcement, your building and safety. It's that kinds of thing. They have police power, but it's in your residential dwellings, okay? So police power is key right now, or actually law enforcement power. So an arrest on the property, a nuisance at the property, those are things we could evict for, even though we've been asking for the money, and it not be considered retaliation because it's our police powers that are telling us we have to do something. I got a letter from code enforcement saying my tenant has too much trash and debris, or they're doing this, or building and safety sent me a letter. That's a reason we can evict, but we can't evict on cause, if you will, if we've asked for money in the past. Now that is considered retaliation. And I'm only talking about the COVID period. So we want to be really careful what we're suing for at this point, because now there's fines implemented. And I don't like to pay money when I'm losing money, okay? And that's just me trying to get you guys all on my page, is be careful here. Are there cases where owners are not paying for full services only to collect rents? What would be the correct way to handle this? I don't know what you mean by they're not paying for full services. So they did add something to Senate Bill 91, basically stating that we as landlords, if we had to close our pool or our gym inside of our apartment communities, we were complying with a government order, and we're not required to give them a rent credit for not being able to use those amenities based on the government order. So basically what it's saying is, if you had to close your pool because of COVID, gatherings, etc., you don't have to give your tenant a rent credit for having to close the pool. That was a huge question in the beginning of this. Now that is actually written in the Senate bill. Landlords, if they had to close an amenity based on something due to COVID, that the tenant does not get a rent credit for not being able to have that amenity. And then let me go back, because I saw another question come through. Reverse late fees, refund on our ledger only. Do we notify tenant about the reversal? And how are these fees credited towards rent or just left on the ledger as a credit? Did the tenant pay the late fee? Because if they paid that late fee, then you want to make sure you're issuing them a credit. And I always notify them. Hey, just want to because you want to tell them right now, hey, you had some late fees on your ledger that you paid for, but they were during the COVID period, and they just passed a new law that late fees couldn't be charged. So because the law changed, we're changing with the law, making sure you get that credit on your account. So wanted to let you know, because the last thing we want a tenant to do is not be told that they were credited and think that they were charged and then put a lawsuit on you. Okay, we don't want that to fester. We don't want that to grow. We want to notify them now so that it takes away any questions in the future.
Patty, I figured out a way to quickly find out if I did any rent increases.
Yes.
Basically, I would print a rent roll from March 31st.
There you go.
Compare it to a rent roll from April 1st.
I knew if I thought about it long enough, I would come up with
Yeah,
something
it's
too,
like
but I'm
easiest
focused
thing, but
on
just,
this right now. Yeah. There you guys go. Pull a rent roll from last year, pull a rent roll from this year. If they don't match, you have a problem.
March 31st, right? March 31st.
March 1st.
No, April 1st, you said. So March 31st.
No. I want you to go to March 1st. Hold on. Let me look at the law. Hold on. Hang on. March 1st of 2020. March 1st of 2020.
Oh, okay.
Through June 30th of 2021.
So March, not April. Okay.
Correct. See, you guys, we're a big team. We all work together. See how all that works? And this is why I do Wednesdays with Widget, just to keep everybody in the know. Somebody asked if I have previous recordings of our meetings on the website. Yes, I do. They are available for replay. And I believe they're linked to the YouTube channel. And then you guys are going to see a lot more classes starting to come out of me, because not to give you hope, but there is light at the end of the tunnel when it comes to COVID. And I got a feeling this will be coming to a close, hopefully by mid-year this year. So I'm going to start refocusing on leasing and advertising and all those things that crises and how to deal with those, preparing ourselves for court and trial and what we can expect. So I'm going to start getting back into the groove as far as educating in general on property management, practice, procedure, process, whatever you want to call it, a better insight, avoiding litigation and things like that. I'm just trying to give you guys the heads up so you know what we're looking for going forward. I don't want to keep talking about COVID until COVID's gone. And then I'm sure we'll still be discussing it as it evolves until it comes to a close, but I don't want to make it our main focus is what I'm trying to tell you. I believe it was week before last, we did that class on understanding the terms of your written rental agreement. I got so much feedback on that of people telling me how helpful that was and how that really helped them understand better. So that's my goal, is to take that area that we're all kind of, I'm not sure what this means, and focus on that. Let's dive deep into that and make sure everybody understands how that works, just so that we can better ourselves as a whole. And if anybody
Please
has
find a
anything,
way to. Yeah, I'm
Go
sorry,
ahead.
Patty. Is there any
No,
way?
you're fine.
Is there any way we? Yeah, is there any way we could pay for that class that I missed, and so I could watch on YouTube or somehow? Because
Yeah,
that day I couldn't make it. I'd be more than.
if you're a member of Widget's Way, a paid member, you do have the opportunity to go back and look through the videos on our YouTube channel. So it's part of your membership. If you're having trouble figuring out how to do that, send me an email and my IT guy will get on that right away. But if you're paying either the $15 a month or the $50 a month, you should be able to go back and look at videos that were previously done. Okay. I'm trying, you guys. I'm trying. I got some really good classes coming up for this year. Just so you know, I try to do one at the end of every month on something that matters to us or is important in the industry. And if you guys have something you want me to touch on or a class suggestion that you think you would be most beneficial from, shoot me an email. Let's talk about it, because if you need to know that, I'm sure there's lots of other people that need to know too. So, and that's why I'm here, is to help. Okay. Security deposit refund. Oh, crap. Question: if a tenant moved out after 2 years, waived the initial move out inspection, and upon my inspection after, I got the keys back when I went to the vacant apartment and found the resident repainted all the walls partially with the right color, but with the wrong type of paint. They used flat on semi-gloss. I see that all the time. They use the right color, but they do semi-gloss on a flat wall. And now it looks like, you know, somebody's got wet spots everywhere, but it's actually semi-gloss on flat. You can charge them to repaint the wall entirely. Yes, absolutely. Yep, you can do that. Let me put this in perspective for you, okay? Just so we're all on the same page. And we're talking about a disposition of security deposit, just so everybody's on the same page of what we can and can't charge for. So if you want to paint a wall, like the wall behind me, and paint life has a lifespan of 3 years, according to the Department of Consumer Affairs, which is who governs California Civil Code 1950.5, which is what we're discussing, which is the refund of a tenant security deposit. So the Department of Consumer Affairs is who determines the lifespan on paint, the lifespan on carpet, etc. So big key there, Department of Consumer Affairs. It's where you guys can find out what the lifespan is on things. I could tell you right now, currently,
they have a tenant landlord handbook that they publish.
Yes,
very good.
3 years on paint, 5 years on carpet, 7 years on upgraded carpet. Okay, damage is damage is damage all day long. So if your tenant lived in the property and they spot painted and patched and they put semi-gloss over flat paint, that's now considered damage, and you can charge them to paint the whole wall. There is no wear and tear there. That is damage. Everybody with me? So you don't have to allocate how long they lived there, give them a credit for this. That's damage. Okay. If they don't damage and it's wear and tear, that's when you have to do the lifespan. And I always break it down in months because it's the easiest way to do it. So if you take the amount, divide it by months and work it that way, even Ed's nodding his head, yes, monthly is the best way to go. And then I just always, I don't prorate per day. I prorate by the month. And I eat the extra, or I eat the month, just so that I'm erring on the side of caution. So if it was 3 months and 14 days, I just charge them for 3 months. I forgive the 14 days. It's just better to err on the side of caution in this business. And in the event you get into heavy litigation, you come out looking great because you gave this to the tenant, you gave that to the tenant. And even though it's just a couple bucks here and a couple bucks there, at the end of the day, you look like you know exactly what you're doing, and you're protecting your tenant. Ed's nodding his head because he knows, yes, this worked for me too before. So error on the side of caution, you guys, when you're trying to figure out those prorated things, just do it by the month. And if it's 3 months and 15 days, give the tenant the 15 days, just charge them for the 3 months. It makes you look better at the end of the day. And we're talking about peanuts in the big scale of things. It's just not worth it. Besides, if you went 1 day over on that prorate, they're gonna just tear you apart. So it's much better when you get into court so the judge can see that you gave the difference to the tenant and you kept benefiting the tenant. It just makes you look better as a whole, as a landlord. Also, make sure that you're not charging rent out of the security deposit for the COVID rental period. If you're doing a disposition of security deposit currently, you cannot put COVID rents on there.
Unless
Okay.
unless the tenant explicitly agreed to it.
They have to sign.
Or they have to sign.
So not only do they have to explicitly agree, they have to sign.
An email is not considered good enough for that. It has to be a signature. Okay.
I always use the word wet signature. That means somebody used a pen on a piece of paper, you guys. Email does not suffice. You need a wet signature. Senate Bill 91 clearly states that the tenant must sign and agree. So an email isn't going to necessarily work there for you. It's something they could argue later. Do you prorate rent on a 30-day month? Absolutely. Only on a 30-day month, even for February, even for March. March is 31 days, February is 28 days or 29 days, depending if we have a leap year. Just do it on a 30-day net. That's the way the courts recognize it. So just use the same system the court does. Then you won't ever have to think twice about what you're doing.
It's called a banker's month, I believe.
Yeah, I put it as simple as I can. Most of you, if you use California Apartment Association says that it's 1/30th of the month. They just mean it's a 30-day. Just do everything on a 30-day. It's the same way the courts do it. And then everybody's numbers will match no matter what you do. Where you're going to see that is becoming a problem is this month right here, February. Okay. Your tenants say, why do I have to pay for 30 days of rent when there's only 28 days in the month of February? It's a question they always ask. Ed's nodding his head because he gets this question every February, I'm sure, and it's a nightmare. Here's what I tell tenants, or what I've told tenants for years. Well, if you'd rather pay a daily rent instead of a monthly rent by the end of the year, because there's so many more days with 31 in them than there are with less amount, you'll actually owe me more money. But if you want to do our rent that way, I'd be more than happy to charge you a daily rent instead of a monthly rent. And it usually stops the argument. They understand what you're saying to them and they're just asking questions in general, but that's one of the things I used and it seemed to work well. But yes, a 30-day month.
I also tell them that when they moved in, it was also prorated on a 30-day basis, even if it was a 31-day month. So.
Right. But where you see that argument is in the month of February, because there's only 28 days. And why do they have to pay for 2 extra days of rent? Well, why don't you look at March and, there's 31 days there. So it just depends on how you approach it. But yeah, you want to nip that in the bud very quickly. Now, does anybody have a question I wanted to cover about Senate Bill 91? Notify your tenants about the rights. It's a key point of a lot of caveats in the future. Okay, you're not going to be able to apply for the money unless you've notified your tenant of this right. You're not going to be able to evict for non-payment in the future if you didn't know notify the tenant of this right. So this is the basis of a lot of things that may or may not happen in the future. So that's why we're just saying, just notify everybody, because your tenants that have been paying you are going to continue to pay you. If they wanted to manipulate the system, they would have started doing it long ago. Okay, they're not going to start now. So definitely important there. March 15th, housing is key, 5 a.m. you guys, 5 a.m. No joke. Okay. When the money's gone, it's gone. So we want to make sure we get our foot in the door.
Hopefully their website is strong enough to hold all the traffic.
Well, we are talking about the federal government here, guys. So God knows what's going to happen. But I know Ed's nodding his head because he realizes he needs to get up at 5 o'clock in the morning and do this for some of his owners. So he's, yeah. So it is what it is, you know? Can I unmute you? I don't know that I have anybody on mute, but let me see. I don't have anyone on mute at all. You can unmute yourself in the bottom left corner where it says mute. You should be able to push that and unmute you. You can even turn on your video if you want to. Then I could see you guys. But I'll take questions now. If anybody has questions, you guys can type them and I'll look at them that way, or you can unmute yourself and we'll just kind of play the round robin and go that direction if somebody wants to talk. Here comes a question. Hang on. March 15th application date. Is there anywhere we can preview the form so we're better prepared to complete the form? That's what I was trying to explain to you guys. They're still designing and developing the system of how they're going to allocate this money. And they haven't made the form yet. I don't know that it's going to be a form. I don't know what documentation you're going to have to be able to submit to prove. My guess would be a copy of your rental agreement. Okay. You may need your APN number from your tax bill in order to apply for this. I don't know. As I have more information, I will release it as I obtain it. But I tell you, I am watching that like a hawk so that I can, yes, Ed, I used your word, hawk management, go figure. I am watching that like a hawk just so that I can report back to you guys what you may or may not need. I'm guessing here, Ed, that you're going to need your rental agreement. I'm guessing that you may need your APN number because that defines your property, where your property is. It's also going to define the median income level, etc. So lots of moving parts there, but I'm thinking you might need your APN number. I know you're going to need your rental agreement. And as things evolve and I get more information, I will obviously report that to you because I want to help everybody make sure that they're on the government's bandwagon. Okay. Hold on, I see more questions. I'm trying to get to them. Do we need to reverse other fees such as broken windows, etc.? No additional charges can be charged from the tenant from rent from March 1st all the way through June 30th. So if you had a repair or a damage, I would allocate that in a different way and apply that to their account in a different way. Everybody's like, what are you talking about? I would hold on to those funds and slap it on their disposition of security deposit when they vacated. That way it's not on their ledger as money they owe right now. It's going to come out of their deposit when they vacate the unit. Following me? Okay.
How about having the tenant pay the vendor directly?
You can have them do that too, because that's not an additional charge that you put onto them.
Right.
Can the Senate Bill 91 notification be postmarked on the 28th? Absolutely. It has to be served on or before the 28th of this month. Postmark would be fine. Obviously, we can't apply for the money if our tenants are current as of today, yet we still must notify everyone. Yeah, but I don't fear that because honestly, and Ed's going to agree with me here, if you had a tenant that was going to be dishonest and manipulate the system, quite frankly, they'd be doing it already. They would know. That's what I'm trying to tell you, is the tenants that you have in there, even if they're struggling to pay you, they're still struggling to pay you. And they put their housing first, meaning they want to get you taken care of. They want to make sure they don't get evicted. They're not going to break that at this point. Not for the 4 months left in this Senate bill. It's not worth it to them. And I know you guys are like, but Patty, please, I beg you, put this much trust in me, okay? Just this much. If they're going to be delinquent and manipulative and entitled to something, they'd be doing it already because they already are doing it. They know the rules already. They knew the rules for Senate Bill 91 before you did. Okay, just saying. Those types of tenants, they already know. They're on it. See another question. Sending notice via U.S. Post Office is okay. Should it be certified return? Sending the notice via the U.S. Post Office is okay. No, it should be certified or return receipt. No. The law says to give someone proper notice, you must post and mail, personally serve, or subserve. That's it. So if what we're going to use is a court document to say that we did this, which is the proof of service, we need to do one of those three things: personally serve, post and mail, or subserve. That's it. You can get proof of mailing as an additional protection for you guys, but I'm telling you that proof of service that you sign and agree to is what you need in a court of law to prove it. It's the process and procedure of a court. It's what a judge recognizes. There, let's try that one, okay? It is what a judge recognizes, saying that you said you did this on this day or this time, or you're willing to spend 6 months in jail for perjury. So it's what the judge recognizes. It's what the court recognizes. So we want to do it by their system. So if something happens in the future, all of our ducks are in a row. It's very simple. So post and mail, personal service, subservice, that is considered constitution of service of a document. And I won't deviate from that. I'm sorry. Because now we're talking about process.
Yeah, okay, so if we just mail it with a proof of service, that would be sufficient. Am I correct?
No, because you never posted it.
So you're saying that it must be posted, then you go to the post office, have a proof of service.
Same day.
Yeah.
And it's not
Okay.
proof of service at the post office, it's proof of mailing.
Proof of mailing, okay. Let me just say, I did talk to the rep of Housing is Key. She put me on hold. She says, I'm going to talk to my supervisor about this issue. And she came back, said, we are not saying if you even have to have the proof. We are only saying that you must do this. And that's all she said. Nothing else.
I understand that, but it's not Housing is Key that's going to protect you in a court of law. It's your attorney and your law firm. So you're going to have to prove that the intent was there. And that's why I'm saying, if you just fill out the proof of service and put that in your file, that is what the court recognizes. That is what is most likely going to protect you.
So we have to do it just like we're doing a 3-day or 15-day notice, basically.
Bingo, right on the nose. You got it now. Yes. Thank you. Thank you, David, for helping me explain that the easiest way possible. Serve it like you would any other notice. A 3-day to pay rent or quit. Bingo, you got it. Anybody have anything else, or I will end this for today. I'm sure you guys are sick of hearing me ramble, and we'll be back next week for sure with new updates, additional updates as they come in. And I don't have anything crazy going on this month. I'm trying to think. Yeah, no, nothing crazy going on this month. In 2 weeks from now, you guys may see me with an entirely different background and snow. Yes, I'm on a mission again, outside of the state. So yes, I will be coming to you live from other states here in the near future. Yeah, but we'll still be focused on what's going on right here in California. So no problems, no issues with that. I will go ahead and close this out for today unless anybody has anything else. I see more. Okay, come on. What you got? Give it to me, baby.
This is Karen. How you doing? And I'm sorry.
Hi, I'm good.
Sorry you can't see me. But
hey,
listen,
it's all good.
I'm listening to this SP 91. I sent the request. I sent the little question in regard to postmarked and so forth. because of our concern with one particular tenant. We just got her in there. I just got her in there in November. And already she's been paying, but let's just take this last month. Last time you were on your video, I said that she wanted to pay half and half on her rent, okay? She did ask me about if there were any programs out there, all right? And I've kind of just been sitting and it's like, okay, SB 91's out there. I do need to notify her, but I'm afraid that when I do give her that, she's going to not do the have much rent to, you know, every other week, or she's going to end up going to that 25% thing. I know she's going to take advantage of that. But what I'm hearing you say is,
well,
here's
talking to you, Karen. Okay, hold on.
Please.
Hold on. Here's me talking to you.
Okay.
If she goes to the 25% thing, whether she pays you the 25% or holds the funds and pays you the 25% on or before June 30th, the reality is the 75% becomes consumer debt that you can only enforce in small claims court, and the debt is unassignable, so you have to collect it yourself. Okay, so this is me talking to you.
Okay.
If she's going to pull a slick one and she's going to pull a move on you, wouldn't you rather be in line to get 80% of what's owed to you than dance around the devil of 75% going God knows where, and maybe you can never collect on it in the next 20 years?
Okay. And
so I get that you don't want to notify her of this, but the reality is this is a much better plan than what's already in place.
Okay, because this is like the second, yeah, and I believe she's going to play that because this is the second month. Because that's the one
I understand your concern.
Yeah.
But if we go with how it's written right now and we don't play with the 80%, 20% program, she's going to pay you 25% on or before June 30th so that you can evict her. And then the 75% is consumer debt.
Okay. All right. And I'll talk to you more about
that. So when you
March.
stand back and look at the big picture, taking that 80% through the federal program is a much better option than the 75-20.
Okay.
Because at least it's going to put 80% in your pocket right now versus 25% at the end of June, and the rest of it payable over the next 20 years, if you're lucky.
Okay, so I really have to wait and see what she plans on doing for March.
No, you need to serve her the notice in February and apply for the money on March 15th. For everything that she owes.
And she doesn't owe anything so far.
Right.
Okay.
But we don't know what she's gonna do. You're not gonna be able to evict her for non-payment if you didn't notify her of this. Remember, notifying them of this has a lot of moving parts and caveats for things you want to do in the future.
Okay, so
is this Senate Bill 91 to be served on a tenant who has not paid rent for years and has damaged the property, etc., served to everyone, good or bad? Yes, AOA USA it does have this form on their website to answer that question, Teresa. Hold on. I'm still reading. Is Senate Bill 91 to be served even on a tenant who has not paid for years? Yes, absolutely. If they haven't paid you for years and they've damaged the property, this is a chance for you to get 80% of what they owe you. Please note that February 28th is a Sunday, so you'll need to postmark this on the 27th at the latest. Thank you, Ed. This is what I mean, you guys. We're all a team, okay? A lot of people don't understand that, is we're all a team. And that's why I told everybody, AB 3088 is going to change, but not on January 31st. It's going to change on or before the 29th. Son of a gun if they didn't pass it on the 28th. But what do I know? I'm just a blonde. But that's all of us working together as a team together, you guys. Again, we're all in the same storm. We're not on the same boat. Okay. And we're all here to help each other.
Okay.
Hold on, Teresa. If a person sees me and I put the notice on their door, is that sufficient service? You just need to fill out a form called a proof of service. That is what is going to ultimately protect you in a court of law.
And mail it. I would still mail it, even if you posted it.
If you post it on their door, you have to mail it. If you personally serve them and hand it to them, you don't have to mail it.
Okay. Okay.
And I hate subservice, so I don't like to talk about it. And I'll tell you why I hate it. 9 times out of 10, the person that you hand that to, that you sub that to, is a minor. They may not look like a minor, but they're a minor. And they're going to scream that when they get to court, and that puts you in a bad position. So what I've done in the past is I've knocked on the door wanting to personally serve. Kids said, oh, sorry, my mom's not home. I've told them, okay, can you go ahead and shut the door? I have to tape this notice there. I didn't give it to the kid. I taped it on the door. That is considered posting and mailing, because the same day I'm off to the post office to mail a copy of what I posted. I didn't give it to the child. See how that worked? I've told him, okay, I need to give this to your mom. So can you shut the door so I can post this notice on the door? I make it very clear. I cannot give this to you. I need this to go to your parent. So that's how I handled that. Okay. I'm old. I like it. I like that so far, Teresa. I'm old too. I don't want to get near this druggie. Then here's my opinion to you.
You get a process.
Hire a management company. Hey, Ed, I'm getting there. Come on, slow down. If managing your day-to-day operations of your investment property isn't something you feel comfortable with, hire a professional management company to do that for you. That's why professional managers are there. They're there to help you, because everything is not sunshine and roses in your life. And they know that that's why we call them. So definitely something that you could take into consideration is hiring a management company. You can also contact your law firm, your legal services. They will do that for you as well. Yes, Ed, people know to call you. He's like, call me, Hawk Management. I got you covered.
Thank you.
Hang on. I saw something else come through. Let me go back. What's proper service? Physically putting it in their hand would be personal service. There's 3 types of service on a proof of service. So putting it in their hand is personal service. You just sign the proof of service that you personally serve them. Posting and mailing, meaning you posted it, meaning you taped it in an obvious, conspicuous place on the front door, on the front gate, whatever their first point of entry is into the property, and mailing them first class mail. So regular snail mail, you guys, nothing fancy. That is considered posting and mailing. That constitutes good service. And the other one, which I do not like to use, is subservice, meaning you're not giving it to the tenant, you're giving it to somebody else at the property that is 18 years or older. 9 times out of 10, that person is a minor, and they don't disclose that they're a minor at the door. And I've always taught that to my kids, is don't tell people how old you are when you open the door. So whole different issue there.
Patty, I think that the question was more if you're doing the personal service, do you have to give it hand to hand, or can you put it in front of them? Or
personal service is, hi, Ed, I have this document for you. Ed takes it out of my hand and says, what is this? He's been served right there. As soon as he touches it, he's been served.
I think their question is, what if they refuse to take it?
Then tell them, okay, no problem. You don't have to take this. Here's a piece of tape and I'm posting it on your door. Now I'm mailing you a copy the same day, post and mail. So you don't necessarily have to get in a fight and an argument with them. Another key thing, you guys, I used to do this a lot, especially with my properties where there might be someone that is altered on a chemical substance in the property, is I always make sure I either go there really early because they're not awake yet. And I knock really quietly because the court says you have to knock. That's what Ed stopped smiling. So tape it on the door, knock, and run like hell. So I've done that too. I'll own it. Okay. And you know what's funny is I know they can hear me in my stilettos running clack, 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 down the driveway, but hey. So we've all done it. You know, you tape it on the door, you knock, and then you run. But that would be considered, knocking is always a requirement when posting a notice. Okay, just so you know, not ringing the doorbell, knocking. Some of us have small hands and we knock quieter than others. I'm just saying. And then you get that property manager that goes and knocks on the door like the cops are coming in. And I've had tenants tell me, damn, you knocked on the door like the cops. Well, hey, I got your attention, didn't I? I'm here. Let me see what other questions have come through. City of LA, downtown LA, throwing it at her into her unit, is that service? Personally, yes, you could just throw it in the door and walk away. That's personal service. She opens the door this far and you shove the papers in the door, she's been served. Again, you guys, this is just a notification of a program. It's not like you're giving them an eviction notice, okay? So I get that they may have that mentality, but you need to chill just a wee bit and try to be a little bit more approachable with them. It may help keep that landlord tenant balance right, which is really hard to get control of if you lose that balance. And again, another one of the classes I teach is keeping that landlord tenant balance right. You know, if you keep it like this, usually it's pretty smooth sailing. Once you get that balance out of alignment, that's when things go cattywampus. And we usually need legal counsel or law enforcement to help us get control back. So hey, it happens, unfortunately.
Ed, can you give me your phone number, please?
Ed?
Yeah, yes, absolutely. I'll put it again in the text box here so everyone has it.
Because they're going to call you and be like, Ed, we need a property manager.
Sure.
I don't think, do I have any other property management companies in the house that do single family or multifamily management? Because if you do, put up your information as well so that they have options to contact. That way we're not just helping Ed here. We got to help all of us, Ed. We're all in the same storm. So anybody else that does single family,
no problem.
anybody else that does single family, multifamily, please share the love. We're all a big family here at Widget's Way and we all help each other. So I don't want you to think there's only one person you could take care of. Yes. I know that there's some management companies out there that specifically do multifamily only, some do single family only, and some do a conglomeration of all, including industrial management, commercial management, etc. If you guys are ever looking for somebody to help you manage your investment property, you can always call me. I'm going to be extremely honest with you. I'm going to refer you to someone that uses Widget's Way, because when things go wrong, who do they call? And that kind of keeps me in the loop as to helping assist manage your property to the best of my abilities, not only to the best of their abilities. So I tend to recommend people to someone that uses Widget's Way. That way I know if they get into trouble or have an issue that they're concerned with or don't quite know how to handle, they're going to contact me. And that's who I want to put you in contact with. That way I'm still in the loop, so to speak, but usually only if there's a problem.
Would it be possible for you to email a list of landlords that in your view are in good standings?
Well, I can also tell you there's some questions that I always tell my owners. You want to ask the property management company, and there's some good ones. Are you a licensed real estate agent working under a broker? That's a requirement for me because I want accountability. I want to make sure. And then I ask, when's the last time you took a fair housing course? That's something that we want to know. Remember, we're responsible for what comes out of our property managers' mouths. So you want to hire somebody that's going to do good for you. I also ask them, when do I get paid? That's an important thing for me. If they're going to hold my money back for a month and there's a month's delay in me getting my properties, I want to know that too. So key things that I always ask the property, thank you, Gio. I see that too. We got like 3 property management companies in the house today. Yay! So also Pride Properties is here and they do manage single and multifamily. So you guys have a little list going. I love this. This is awesome. And I was actually thinking of putting a vendor page on Widget's Way, giving that list right on the website. So I'm working on that with my my web team, my IT team, to get that up for you, David, but I'll work a little bit harder in that area. I've been so focused on the new Senate bills. I haven't been focused on the changes that we want to make to Widget's Way. So just so you guys know, I want to have a vendor page up there with the apartment associations that we're involved with. That way you know where to reach to get a hold of them, with vendors in the area that do plumbing, restoration, carpet cleaning, things like that. Sometimes it's a nice, easy tool to have there. And then, yes, by all means, we could add some property management companies to that as well, to help you find the management company that would work best for you. Again, this is more of an area of what your apartment association does for you, but I'd be more than happy to help. And then let me see if there's anything else. No, I'm going I'm going to see my fiance, and he doesn't know I'm coming, so shh. It's a surprise. I don't know if you guys have followed Widget's Way throughout the COVID pandemic, but when the pandemic first hit, I think I spent 3 months on the East Coast. There wasn't a whole lot for me to do here, except report to you guys weekly what was going on and how to err on the side of caution and keeping the balance right. And in the beginning, you know, none of us knew what to do. And I was explaining, they're going to keep throwing mud at the wall until something sticks. And when it sticks, we're going to have new laws. And so far, that's what's happened. So again, I can work from anywhere as long as I have an internet connection and a phone line. I'm good to go. I can help you guys no matter where I am. So this isn't the first time I've done this. I do this quite a bit, actually, and it seems to work out well. On September 11th last year, I actually did a class called How to Deal with a Crisis or Crisis Control or something along those lines. And I actually did it from one of the 9/11 memorial parks in Pennsylvania. So that was really neat. I thought it added a nice touch to the whole class of crisis control and how to deal with a crisis. So I try to keep all of that in consideration when I'm picking a venue to do a class from, if you will. Okay, if nobody has any other questions, you guys have a great day. You guys know how to find me, hunt me down. We'll be back next Wednesday for sure, okay? Should have some more updates for you guys, more clarification on the new law. Again, we learn a lot more about it as it continues to evolve. We get case law here at the law firm. For those of you that don't know, I am currently employed at Fast Eviction Service. So I work hand in hand with attorneys all day. When they come back from court, I'm listening. What happened? What's going on here? Just to give you guys all a heads up, in LA County, don't panic if you're in a jury trial with BASTA right now. One of the trends that we're seeing that just recently started, thank you, Rosanna. One of the things that we're seeing as a trend coming through from BASTA is what they're asking to settle for on their very first request to try to settle a case is extremely high. So remember, their first offer isn't necessarily what you have to take. That's what your attorney's here for, to go to bat for you. Okay, but we're seeing BASTA throw out ridiculous numbers to try to settle a case, like $150,000. Don't panic, don't freak out. Your attorney's going to go to bat for you and try to come to terms with a much more reasonable amount of money in the event that it's going that way. I'm just letting you know, a tactic BASTA is using right now is very high settlements for their first offer. Mind you, that was their first offer. Usually there's 2 or 3 before an agreement can be made. So don't panic if that happens to you. Know that it's just part of the process and procedure and the intimidation tactic that they try to put on all of us landlords.
Thank you,
thank you, you guys. Oh, thank you. And if you guys need anything, you know how to hunt me down, you know how to find me. You can always call Fast Evict and ask for me. I'm at extension 210. I'm on the phone a lot. So sometimes texting me, Ed knows, emailing me is good. Text is the absolute quickest, best way to get a hold of me. I watch those text messages like crazy. So you can text me on the Widget Way line and say, hey, I just sent you an email. Ed does this. Can you review it for me? And boom, that told me, hey, I got an email, because I'm just as busy as you guys are every day. I'm sure you can imagine. So with all of that that's going on, disclose to your tenants by the end of this month, remove any additional fees that they've had since the pandemic has started, you can't charge them fines, fees, interest, late fees, rent increases, no additional expenses to the tenant, okay? And thanks, you guys. Have a great week, and
Bye.
I'll see you next Wednesday.
Thanks, Patty.
All right, bye, everybody.